Hi everyone, Daniel Chessmore here, continuing on our series with civil procedure. This will be bar review for civil procedure, covering what might be covered in a two-semester traditional first-year class. So starting with the concept of personal jurisdiction, this involves a court's ability to exercise power over parties or their property. There are three questions to personal jurisdiction's determination. Is there a traditional base of personal jurisdiction? If there's no traditional base, does a long-arm statute apply? If there is no long-arm statute or traditional basis, or maybe if there's no traditional basis but the long-arm statute applies, is its application constitutional? So traditionally, defendants could be required to litigate suits only in certain fora, including the states where they resided or where they were physically present, in Pennoyer. Under Pennoyer, difference between jurisdiction in personam and in rem, quasi in rem. There was no way to obtain in personam jurisdiction over an out-of-state defendant. State had exclusive jurisdiction over people and property within its borders, established in Pennoyer, reaffirmed in Burnham. Also, exercise of personal jurisdiction. Also, the exercise of personal jurisdiction there. Let's see here. Sorry, I'm getting a lot of text messages and I was a little bit distracted. So traditionally, defendants could be required to litigate suits only in certain fora, including the states where they resided or where they were physically present. Pennoyer. Under Pennoyer, there was a difference between jurisdiction in personam and in rem, quasi in rem. No way to obtain in personam jurisdiction over an out-of-state defendant. State had exclusive jurisdiction over people and property within its borders, established in Pennoyer, reaffirmed in Burnham. Also, exercise of personal jurisdiction is limited by the Due Process Clause of the Constitution under the Fifth Amendment, which limits life, liberty, property by the government. Non-residents must be served with process while in state, or if they have property in state, that's in rem, or must be attached at the beginning of the suit. Doctrine was expanded to the point where merely driving in ascertainable in a certain state became a basis for personal jurisdiction, like in the Hess case, even if the driver returned to their home state. In Hess, driving in a state, there was implied consent there to appointment of the state registrar as an agent for receipt process in all actions arising out of an accident or collision. So states also have developed long-arm statutes allowing for service of process or people not physically present in a state in order to exercise personal jurisdiction or obtain personal jurisdiction over non-residents. In International Shoe, the Supreme Court introduced new doctrine of minimum contacts with the forum state on which suit is brought as a basis of personal jurisdiction. A state has personal jurisdiction over anyone served process residing in or present in that state, per Burnham, any property in that state, in an in rem proceeding, like in Schaefer. No quasi in rem proceeding if no minimum contacts as per International Shoe. And so quasi in rem basically only has small utility if no long-arm statute, or if you want to grab property, any citizen of that state, anyone who wants to consent to jurisdiction, like in the Carnival Cruise case, there is a forum selection clause. One can consent by making a special appearance and arguing on the merits, by not offering any evidence to disprove personal jurisdiction. So our general rule here is anyone with such minimum contacts with the state, such that traditional notions of fair play and substantial justice are not offended. So here are the traditional bases of personal jurisdiction. There are types of personal jurisdiction where in personam is a classic, where court exercises power to render judgment for or against a person via their presence in the forum state plus service. That's presence. The second is domicile, highlighted here, preserve and intent to remain in the state, and consent, or implied or express. And so we'll go over the first half of civil procedure. I also have relevant case law here that we might go over if the need comes, but I think I have that discussed in my written outline here. I've got flashcards as well. I've got more outlines that cover both civil procedure 1 and 2. And so I think I also have got very cool charts similar to my typical type of artwork that I have here. This is more civil procedure 2 that we'll cover. So that will be the layout of our session. I'll try to do these in 1 hour increments, and possibly we can do this in 3 hours. So If you have no traditional bases like consent, domicile, or presence, go to the minimum contacts analysis. In international shoe, remember that a defendant is subject to personal jurisdiction only where he has sufficient minimum contacts with the forum state so that the suit does not offend traditional notions of fair play and substantial justice. So two kinds of in personam jurisdiction. There's a general, where the defendant can be sued in the forum state for any claim arising everywhere or anywhere. General jurisdiction is a right of the court to assert personal jurisdiction over defendant, where either defendant is a resident of the state, individuals like domicile, corporations, incorporation, and nerve center, and non-resident defendant has contacts in state which are so systematic and continuous, like an international shoe, it would not be a violation of due process to bring defendant into court for matters unrelated to those contacts. Also, it isn't unreasonable to ask defendant to appear in unrelated suits there. And here are a number of cases here. Helicopteras, sporadic contacts are not held to be sufficient. Simply doing sporadic business in a state doesn't necessarily qualify as continuous and systematic. No general jurisdiction there. Much higher minimum contacts to satisfy this type of jurisdiction, like negotiations, purchases, framing, payments not enough for helicopter. Difference between contacts that arise out of and contacts related to the cause of action. When looking at general jurisdiction, you cannot just look at sales activities. The holding there, cause of action did not arise out of contacts. Negotiations, purchasing were not systematic or continuous enough to satisfy requirements for general jurisdiction. And in the dissent there, contacts were sufficiently related to cause of action. Test should be whether claim is related to, not arising out of those contacts. So this case is the first court case that distinguishes between specific and general jurisdiction, but it doesn't tell us the point at which contacts support general as opposed to specific jurisdiction. Then we get a case for Perkins, where continuous systematic activity in the forum state gives forum court discretion in whether to take the case. In Perkins, this was a Filipino company doing business in Ohio, established that general jurisdiction, even if continuous and systematic activity was established after claim arose. That company there in Ohio, after claim arose, the Supreme Court says Ohio could take that case. And so in Pebble Beach, another case, a website reaching people in a state doesn't qualify as purposeful availment for minimum contacts. We get the Calder effects test in that case, used to determine minimum contacts, not exclusive to websites, where we look for some sort of commitment to, of an intentional act which was expressly aimed at the forum state and cause harm likely to be suffered in the forum state. In Finnair, this is the presence of an office in New York, which establishes continuous and systematic contact. It didn't matter there that the office could actually do business. In Goodyear, for example, products ending up in the forum state via the stream of commerce doesn't qualify as continuous and systematic, no general jurisdiction. Stream of commerce argument was too broad to convey general jurisdiction. Accident there versus the real world implications would create too much interference from in that regard. Okay, so moving on. In specific jurisdiction, a defendant can only be sued for claims arising in the forum state. There, in specific jurisdiction, subject matter of action must relate or have a specific connection to the forum state. A non-resident defendant with limited contacts is subject to personal jurisdiction under the long-arm statute. And so the cause of action arises out of those minimum contacts, and the long-arm statute authorizes exercise of jurisdiction. And jurisdiction does not offend traditional notions of fair play and substantial justice, like an international shoe. There's a two-step framework that we apply for personal jurisdiction. We first ask one, is there a state statute that authorizes its courts to exercise personal jurisdiction under the circumstance of the case? And secondly, we ask if the answer to one is yes, where there's some sort of state statute that authorizes a court to exercise personal jurisdiction. We ask, does the exercise of jurisdiction comport with due process clause under a constitutional analysis? And then we get the minimum contacts test from International Shoe, where in order for a state to exercise jurisdiction over an out-of-state defendant, defendant must have minimum contacts with the forum state such that maintenance of the suit does not offend traditional notions of fair play and substantial justice. We look at the quality and nature of their contacts. We ask, was it intentional? Did the defendant target the forum, like in McGee or the Burger King case? Did the defendant purposefully avail himself of the forum state's laws, like in WWV? Was it foreseeable, like in WWV? We also look at relatedness, where defendants' contacts are related to the lawsuit, like specific jurisdiction, International Shoe, and McGee. If they're unrelated, we ask, are defendants' contacts so systematic and continuous as if defendant is at home to justify general jurisdiction, like in McIntyre? So we look to reasonableness and fairness, state's interest versus the burden on defendant, like in the Asahi case. International Shoe, Missouri company had salesmen in Washington who were served with notice. The rule there, to exercise in personam jurisdiction over a defendant, you must have certain minimum contacts with the forum state, such that maintenance of the suit does not offend those traditional notions of fair play and substantial justice. Maximum extent to which a state can exercise jurisdiction consistent with the Constitution would seem to be systematic and continuous. Due to the company employing salespersons to work in the state, look for irregular and causal activity, which, however, alone are not sufficient. Service of process establishes personal jurisdiction over a defendant who is subject to the jurisdiction of a court in the state or where the authorized or is authorized by a federal statute. Minimum contacts with a forum state, some relationship with forum, some activity with forum, direct. Look for foreseeability enough for those notions of fair play and substantial justice. If the standard there is not met, the jurisdiction violates the defendant's 14th Amendment right to due process. And we think a lot about procedural due process in the context of civil procedure, like notice and fair play and substantial justice. But we look at procedural due process, mostly in this class, versus the substantial due process that we talked about in con law. So this is the evolution of minimum contacts analysis. The former doctrine prior to International Shoe was this consent theory. These are traditional notions where presuppose that a corporation could transact a business in a state only with that state's consent, which requires service of process in that state. Or presence theory, corporation is, they're amenable to process if it is doing business within the state in such a manner and to such an extent to warrant the interference that is to prove there, and traditional bases for jurisdiction, territoriality, sovereignty, where the state has exclusive jurisdiction over people and property within its borders. That was established in Pennoyer and reaffirmed in Burnham. Importance of a state outside of its territory is not true anymore. Territoriality applies even for voluntary transitory presence, like in Burnham. Tagging jurisdiction allowed to overrule principles from International Shoe. A non-resident defendant can still be served while physically present, like in Burnham. In Burnham, if defendant is present in the forum state and served process there, no minimum contacts required, per Scalia. 14th Amendment does not deny a state jurisdiction over a person personally served with process while temporarily in a state, in a suit unrelated to his activities in the state. We look to the traditional notion of jurisdiction based on physical presence, which will survive even absent minimum contacts between defendant and the forum state. Doing business in the state courts as presence for corporations, also a form of implied consent. We also look, in addition to those traditional bases of territoriality and sovereignty, this concept of domicile, where the state has jurisdiction over its dominion, over its domiciliaries, regardless of where they are located. You don't lose domicile until a new one is acquired. Jurisdiction also applied to absent citizens, so we get, in this sense, a physical presence, the intent to remain somewhere indefinitely, only changes from birth by physically moving with intent to remain in the state indefinitely. Determined by person's center of gravity, like their home, their work, where they pay taxes, their cars, where they vote. Agency is another concept. The jurisdiction over an appointed or state agent is enough, even if a state decides that an agent is a prerequisite for use of state services. If an agent is acting in the interests of individual, then he carries jurisdiction. So consent, jurisdiction is given over plaintiff for being in that forum if a defendant files a cross complaint. Express consent, boilerplate provisions in contract or adhesion contract using form selection clauses like Carnival Cruise Lines. You can consent by contract to your jurisdiction. So the court leaves wiggle room there to rethink of contractually selected forum as irrational. Where judicial scrutiny for fundamental fairness, we must consider fairness. And then we look to implied consent, where special exception to territoriality and interests of public safety limits applied consent to proceedings deriving from accidents or collisions on highways, for example. And so we will cover all this relatively quickly. There's a lot to cover here, so you can always pause and look at the written outline. I'm just going to read over my notes here that I took from reading the cases, from what I gathered from trying to synthesize the actual FRCP, and feel free to comment if you have any questions. So in the case of Gray, there is a stream of commerce which makes the Titan defendant answerable for the damages done by its product in Illinois. So consent is also given where defendant fails to assert it has a defense. Per Rule 12b2, it must be asserted early in the trial. Corporate presence, jurisdiction in state where incorporated and state where doing business. That Gray case that we talked about, where we talked about how minimum contacts were satisfied by a defendant that has substantial connection with the forum. Relevant test is in Gray is whether defendant engaged in some conduct by which he may be said to have invoked the benefits and protections of the law of the forum state. The holding there is that there is a Titan valve contract with or contact with state sufficient to establish jurisdiction, sufficient if act or transaction in question has substantial connection with the state of the forum, specific jurisdiction there, not only about quantity, but chiefly about quality and nature of activity. So state must adopt a long-arm statute to expand their jurisdictional reach. Per Gray, ask yourself, was a tortious act committed in the forum state? If yes, then is the assertion of the jurisdiction constitutional? If the tort is committed where the resulting damage occurs, where it's felt, where the consequences are felt, then continuous activity is not required and the commission of a single tort within the state has been held sufficient to sustain the jurisdiction. So applying general flexible tests, question is whether the activity conducted within the state is adequate to satisfy due process. Depends upon the fact whether defendant engages some act or conduct with substantial connection with forum by which he invoked the benefits and protections of the law in the state. Responsible Titan would contemplate products would be sold in Illinois. Defendant benefited from that law there. The international shoe minimum contacts requirement is satisfied even when a corporation conducts business or conducts no business within the state, so long as the act gives rise to the lawsuit has a substantial connection to the state. So here, defendant did not claim isolated experiences or instances. After international shoe, state begins to enact long-arm statutes. In Illinois statutes, stated non-resident who commits a tortious act within Illinois commits to jurisdiction under the Civil Practice Act 17b. Civil Practice Act 16 provides that summons may be personally served upon any party out of state. The two-state analysis of personal jurisdiction in Frey again asks, does the party fall within the reach of the statute? There, the defendant said no because tortious act happened out of forum state, but court said yes because tortious act was when it caused injury, which took place in the forum state. And then we have an expanded basis of personal jurisdiction. Minimum contacts, cause of action arises from the conduct or the contacts under specific jurisdiction. Cause of action does not arise from conduct or contacts for that second part. Up top in the middle, continuous systematic activities, contacts with state. Under the first category, always has a general jurisdiction, like an international shoe. But in category 2, general jurisdiction at court's discretion. And lastly, isolated and sporadic conduct with the state. You can possibly have specific jurisdiction, but this depends on the nature of conduct in Hess, or you can never have jurisdiction, like in Hansen. So we'll review those cases when we get to the note cards piece, and we will summarize a lot of these rules that we're discussing. I think that for now, these are just really useful, just general concepts to go over. And then later on, we'll delve into complaint and answer and the actual procedure piece. I think all of these are, of course, related to civil procedure. And as you see here, we've got a lot to cover, so I'm going to try to go a little bit faster. You could always slow it down. Apologies if I'm going too fast. Just want to save time since I know you've got a lot of bar materials out there that you got to go through. So long-arm statutes permit states to obtain jurisdiction over a person not physically present at the time of service, grants jurisdiction arising from action that causes tort within forum state. 3 questions to determine personal jurisdiction. Is there a traditional base of personal jurisdiction? If there's no traditional base, does a long-arm statute apply? And if there's no traditional state base, but there's a long-arm statute that applies, is it constitutional? And is it constitutionally applied? On the bar exam, read the statute and determine if it's applicable or inapplicable. If it is inapplicable, go to the 3rd question and just do your regular minimum contacts analysis. So the stream of commerce, purposeful availment, voluntary affiliation. McGee, International Shoe, we look at quality, nature of the contacts under the minimum contacts analysis. A state can exercise specific in personam jurisdiction, personal jurisdiction over a party who has a single contact with that state, provided it gives rise to the claim and was purposefully undertaken. So court uses 4 factors to determine if personal jurisdiction or were upheld or specific jurisdiction were upheld. Defendant solicited business from California in the forum state. Defendant's contacts with California, the forum state, and plaintiff's claims were related, where the lawsuit arose directly from the insurance policy. In California, the forum state had an interest in the matter. State's interest in providing the forum was that California didn't want its citizens being swindled by out-of-state businesses. California was a convenient forum there. In the notes, hints of purposeful availment test in Hansen fleshes out concept of specific jurisdiction in International Shoe, interest balancing on this case, analyzing the benefit of the party, the laws of the forum state versus the inconvenience invoked in requiring the out-of-state party to appear in the forum state, indicates idea of minimum contacts could continue to expand, approaching meaninglessness. Hansen reins in the limits. Here, jurisdiction over out-of-state defendants exists because defendant took actions that were purposefully directed towards a forum state, knowingly entered into a transaction with citizen of forum state. Perhaps something special about insurance contracts to have more state regulation. Contract has substantial connection even if a company doesn't. In Hansen, minimum contacts must be volitional, cognitive, and beneficial to defendant. Here, no jurisdiction over trust fund just because client moved after trust was started. Cannot be based on unilateral party other than defendant. Defendant must purposefully avail himself of the privilege of doing business in that state, thereby invoking benefits and protections of its laws. In Hansen, a state may not exercise jurisdiction over a party if the party's contacts with the state are negligible and non-deliberate, and the claim does not arise from those contacts. So Hansen made clear that some exercises of jurisdiction would be struck down, if not to protect the due process interests of the defendants included, then to protect sovereignty of other states. Also, Hansen introduced that defendant must perform some purposeful, deliberate act to associate itself with the forum state. Here, the act of moving to Florida was not indication by bank it wished to conduct business in Florida or benefit from Florida's laws, without some action by which the defendant purposefully avails itself of the privilege of conducting activities within the forum state. This activity and its benefits and protections of its laws, personal jurisdiction is not established there. So Hansen checks McGee that some exercises of personal jurisdiction under minimum contacts are actually not allowed, if not to protect a party's due process interests, then to protect sovereignty of other states. Also introduce the idea that party must perform some deliberate, purposeful act in order to associate itself with the forum state, and the concept that the contact in question must be a result of D's purposeful availment of the laws of the forum state. In McGee versus Hansen, McGee, there was a policy set up in California, and it stayed in California. Hansen, trust set it up in Delaware and moved to Florida. Trusting Hansen did not purposefully avail himself to Florida's laws, since their defendant in McGee did, however, soliciting in California, continuing California policy with California resident. The intentional act in that case, we looked for foreseeability of being sued in the forum state, benefiting from such protections by law of the forum state, and a sense of fairness in both cases there, where public policy favored giving policy beneficiaries their due under McGee, and public policy in fulfilling intent of maker of trust like in Hansen. So purposeful availment in doing business in the forum state. Consequences of act cannot be too remote per Green, and effects without purposeful availment is not enough, like in Kukla versus Superior Court. In Kluko, it reaffirms Hansen states that even if a long-arm statute applies, there still must be purposeful availment of the benefits and protections of the state laws. And in Kluko, a state may not exercise personal jurisdiction over a defendant who has not purposefully availed himself of the benefits of that state, even if the state has a strong interest in the litigation. So a dad's act of buying a ticket, which was a purposeful act, but hardly causing any effect, this is where the courts would actually apply the effects test, which is usually used in connection with wrongful acts committed outside a state, which has caused harmful effects within it. Bad argument that dad benefits from law from daughter's presence. Any benefit comes from daughter does not live with him, not because she lives in California. This decision actually reinforces WWVW, since the rule there that some purposeful act by defendant is required to ground personal jurisdiction. So here, purposeful availment, remember the two purposes of minimum contacts there: protects defendant against burden of unfairly litigating in a distant and inconvenient forum, and also it prevents the states from reaching beyond their limits of state sovereignty. And here we get this notion of the stream of commerce. So commerce limited by WWVW in that case to include expectation that goods will be purchased by consumers in the forum state. And I've actually have all of these cases here. We can go over each of them. We could probably save that towards the end. You can skip this. We're just going to go over the general concepts. But if you need to go over some of these cases, I have them here as well. So we can definitely do that. I'll probably just save that towards the end, just so we have enough time to go over all of these. A lot of different cases. I think we have them all here. Sorry, they're kind of out of order. Oh yes, here it is. WWVW, their Worldwide Volkswagen Corp versus Woodson, and we've got a lot of data on these cards. We'll probably do the cases last and just go over the general concepts. And so there, stream of commerce limited by WWVW to include expectation that goods will be purchased by consumers in the forum state. In WWVC, the defendant itself must establish contacts with the forum state such that it would reasonably anticipate being hauled into court there. Foreseeability of unilateral activity by another related party is not sufficient. Remember, minimum contacts must be satisfied before determining fair play and substantial justice. We look to reasonableness. Foreseeability is in relation to being brought into court, like in WWVC, auto accident in Oklahoma through a car that was sold in New York. Fair play and substantial justice, reasonableness. There, due process for defendant White for all parties involved. Per Brennan's dissent in WWVC views contacts between all parties, litigation, and forum state. White admits in WWVC that burdens on defendant are not determinative. And here, foreseeability is not enough because defendant's conduct and connection with the forum state must be such that he would have reasonably anticipated being hauled into court there, and affirms the minimum contacts requirement, but emphasizes concern for defendant in light of other relevant factors, looking to such the forum state's interest in adjudicating the dispute per McGee, the plaintiff's interest in obtaining convenient and effective relief per Hess, interstate's judicial system's interest in obtaining the most efficient resolution of controversy, states shared an interest in furthering social policy, and then we get this general rule here that a state cannot exercise jurisdiction over defendant who has not deliberately sought contacts with the state, regardless of fairness and convenience. Defendant must have chosen to have some contact with the state. We look to considerations of fairness, convenience, and the interests of the state in overseeing the litigation, which are otherwise irrelevant. Minimum contacts, again, must be based on some act by defendant. We look for those key words: purposefully availing himself of the benefits and laws of the forum state, result of the requirement that jurisdiction should not be exercised when it is inconsistent with traditional notions of fair play and substantial justice. So reviewing here the statutory basis for personal jurisdiction, the long-arm statutes, we ask first, is there a statutory basis? A state may grant its court's jurisdiction up to the constitutional limit, but it doesn't necessarily have to. Every state has statute granting jurisdiction over the traditional bases. Also have statutes per Hess based on implied consent. Long-arm statutes allowing jurisdiction to be extended over state lines. There are two kinds. There is the California type, allowing jurisdiction up to and including constitutional limits. There's a more common type where statute or jurisdiction over certain areas like entering contract in forum state, or it could be transacting business in the forum state, or some other form of purposeful availment. And then you have to ask yourself when you're doing your analysis here, is it constitutional? Because states may not exceed the limits of the 14th Amendment due process clause. Ask how personal jurisdiction is authorized by long-arm statutes, determine the meaning of the long-arm statutes, and ask if it is consistent with due process of Constitution by applying international issue minimum contacts. So still got a long ways to go, but we'll power through this. They're fundamentally unfair to hold Seaway and WWW responsible for the actions of others, but minimum contacts requirements also limit jurisdiction in order to protect states' interests from other states. So unless defendant has purposefully availed himself of the laws of another state, defendant's state sovereignty should not be challenged by another state attempting to exercise personal jurisdiction over defendant. Defendant's argument of foreseeability of an accident occurring in Oklahoma is not as important as the foreseeability that a defendant might be hauled to court in another state. In Seaway and WWV, you couldn't have expected this. And the dissent there, per Brennan, other factors like fairness, efficiency, and convenience, since the accident occurred there, the witnesses are all there, and the evidence is there, it clearly should be subject to Oklahoma's jurisdiction, since defendants are not inconvenienced through, despite the defendant's contacts with the forum state, which were not extensive. So note, central question there is, does foreseeability or the stream of commerce equal purposeful availment? No, then it's not a question of whether your product will foreseeably reach the forum state. The question is whether you could reasonably anticipate being bailed or being hailed into the court there. So the case represents the serious split among the Supreme Court between two different views on what is the most important concern in exercising due process. We look at fairness, the due process rights of the defendant, in this case represented by White's majority opinion, and contacts, the interests of the forum state, in adjudicating the dispute represented by Brennan's dissent. And we have a real concern here, where the burden is usually on the plaintiff to prove inconvenience is unconstitutional per Burger King Corp., and their plans prior to negotiation and in contemplated future, consequences sufficient to enforce choice of law clause. And remember, the plaintiff's burden is to show contacts, and the burden shifts the defendant to show lack of reasonableness. So the Supreme Court rules that minimum contacts can be a single contact. Once established, defendant had minimum contacts with the state up to defendant to prove being required to defend there, and would be unfair. So once it's established that a defendant has minimum contacts in the forum state, presumption is fair and equitable to defend there. Contrasts their defendant's response to prove that they're offended. Fair, plain, substantial justice, and always analyze whether or not those are violated. In minimum contacts were established by contract with the forum, with the Florida company, foreseeable to defend in Florida. Florida is actually the most convenient forum for this case, considering the contract. All lawsuits are inconvenient. It is a considered factor. Brennan is in the majority there. And Stevens thought that defendant did no business in Florida, so no foreseeability, fundamentally unfair for defendant and their franchise with limited resources to defend in Florida, since Burger King is a national corporation. And then the notes were that swing voters for Brennan, since purposeful availment here, it made the venue unconstitutional. SCOTUS employed a two-part test in international shoe. Versus here in WWWV. And so remember that here, this sorry, just looking at one thing. So remember to ask yourself if minimum contacts apply. If so, then can the defendant rebut presumption of fairness and place the burden on the plaintiff for showing form so gravely Incorrect serves disadvantage to litigate there. Wealth is not significant. Reach of a federal court is the same as a state court in the same situation. And then we get to the Asahi cases. The Asahi case, where unfairness can trump first prong of minimum contacts. The stream of commerce is equal usually to plus the stream of commerce, and the awareness and act of purposeful directory product to make, and there was Taiwan and a Japanese tire manufacturer over motorcycle accident in California. Each gets these different splits. And so there in the stream of commerce, Asahi's putting product in the stream of commerce. Is that enough for personal jurisdiction? 4 justices in Asahi said yes, but 4 others said it must be accompanied by conduct specifically directed towards forum. So this kind of overlaps with the purposeful availment. Essentially, defendants' knowledge that products sold in state may be enough, but contact is only one with forum state may still be unreasonable for defendant to defend there. And there, the minimum contact set aside in case is decided in issues of fair play and substantial justice. In Asahi, courts were split over whether mere awareness product entered the stream of commerce could end up in the state constitutes purposeful availment. Asahi manufactured parks for Shangxian in Taiwan. It ships 20% business to California. O'Connor, due process requires more than just being aware that a product was entered into the state through the stream of commerce. We look at commerce plus something, and that's highlighted there in orange, where due process requires more than just being aware that a product would enter a state through the stream of commerce. We're looking for commerce plus something else. And designing, for example, product for market and state, advertising there, establishing channels for providing regular advice to customers in that state, maybe billboards, endless examples, and that's where you're going to talk about different facts where it's plus. Remember, commerce plus. It's not just enough to just be within that stream of commerce. Look for some sort of advertisement, something where they would reasonably expect that they would be held to jurisdiction there in a lawsuit. And so we're going to move on. Later on, we're going to talk about federal question and diversity jurisdiction. And then the second half, probably a subsequent video, and we'll do this separately, is when we'll discuss like a complaint and an answer, a demur, motion to dismiss, summary judgment, joinder, supplemental jurisdiction, one of my favorite topics. I always thought that was a lot of fun, and we will have a lot of fun as we discuss that topic here for the bar. And so there, not much left to go. We'll finish this in this video, probably go on for another half an hour, and then we'll go on to the next segment. So in Brennan's dissent, awareness is sufficient as long as it does not violate fair play and substantial justice. Manufacturers, unlike retailers, can not only foresee, but hope they will. Remember that in Asahi and WWWV, in Asahi, to satisfy minimum contacts, there must be some act by which defendant purposefully avails itself of the privileges of conducting activities in forum state. Minimum contacts is defined as minimum degree of contact necessary in order to sustain a cause of action within a particular forum, consistent with requirements of due process. Asahi must have performed some act showing its deliberate intent to take advantage of the state's market or laws. So it would also be fundamentally unfair to require the defendant, in that case, to defend in California, in light of California's interest where it was questionable after the issues were settled there. So not clear in Asahi whether it did not exert or that they did, but it still would not be fair. So we still need to look for fair play and substantial justice. So jurisdiction after Asahi, we still have the minimum contacts test from ISHU, International Shoe. Quality and quantity of actual contacts. We look to foreseeability. It wasn't enough in Asahi. We need stream of commerce plus that personal availment of protection of forum state laws, like in WWWV. So, fair play and substantial justice in Burger King. We get 5 factors there. We look to the burden on the defendant. We look at plaintiff's interest in obtaining relief in that state. We look to the forum state's interest in adjudicating the dispute. We look to interstate judicial system's interests in obstruction in whether or not it's the most efficient resolution of controversies, for example, of total control, or where does it make sense to try the suit. Shared interests of state furthering fundamental substantial social policies. The state have specific laws like certain protections, for example, and we look to the relationship where most justices think fairness factors can only defeat minimum contacts if they are there. So minimum contacts must first be established, of course. Brennan and Burger King says fairness factors themselves can create jurisdiction over even if minimum contacts are not established. Movement from FF&C, state sovereignty, to DP cases, shift from focus on federalism to burden on individual rights. So in McIntyre, court here was split on purposeful availment. Castro there, DeCastro, injured his hand in a machine manufactured by McIntyre in England, who used independent company as distributor. So slightly different from Asahi, since injured person is not person who bought a product. The majority rejects Brennan's view on foreseeability because unfair to allow so many forums. Actions, not expectations, should be what determine jurisdiction. Dissent claimed purposefully availed itself to sell products everywhere. U.S. and not just locations where attended conventions. And there, the rule, products liability cases for those stream of commerce doctrine cannot displace the general rule that the exercise of judicial power is not lawful unless the defendant purposefully avails itself of the privilege of conducting activities with the forum state, thus invoking benefits and protections of its laws. So almost there. We're at least halfway there. I know it's a lot to cover, but all this is like super helpful stuff. So remember, electronic commerce or interest, cybershell, website advertisements are insufficient by themselves. For tech contacts, jurisdiction still covered by traditional principles of minimum contacts, fair play and substantial justice and purposeful availment, online solicitation of phone call, initiation of lawsuits that were defamatory. There's a sliding scale used in Zippo, purposeful direction of activities, like active websites, jurisdiction information only, or passive websites. There was no jurisdiction. Interactive websites that allow user to exchange info, then we might get some purposeful availment. Effect of Calder versus Jones, active websites for translations with residents of a forum state, transactions, but passive websites which do little, then make info available. That's no jurisdiction. First one is yes versus active websites. We want something more than just providing information. So in rem jurisdiction, court exercises power to determine the status of property located within its territory, forum state. Suit involves property in question. So if there's no suit against person because they're not in the state, you can bring suit against whether property he has there, but what must apply the international shoe minimum contacts requirements. So in rem, cases about penalties of property itself, state is an adjudicator there, and they can adjudicate any property within its borders. Per Pennoyer, jurisdiction based on court's power over property within its borders. So quasi in rem, where the court renders judgment against a person but limits recovery to value of property within the territory or the forum state, the suit was brought against the property in order to get that in personal jurisdiction. In Harris, it extends quasi in rem to debts. Debts are located wherever the debtor is. So a person's debt follows where they go. In quasi in rem, based on attachment, seizure of property present in jurisdiction, extended regardless of relationship of property to suit, and seizure of property thought to serve as substantial for adequate service had to occur at outset of trial if done for jurisdictional purposes. Jurisdiction based on property absent from jurisdiction, state in Pennoyer can assert jurisdiction over a non-resident based on his property within the state, and the effect of the judgment there limited to properly attached. So old practice in the forum state service of process for jurisdiction there under Hess. And remember that property expanded to intangible for in rems and quasi-in rem actions under Pennoyer, and also extended to domain there. So here, remember that the overview here of general versus specific jurisdiction overview. In general jurisdiction, you can sue for any claim, not restricted to claims arising out of defendant's contacts with the forum state, unrelated contacts. Specific jurisdiction can only sue for claims arising out of the contacts. Cause of action must arise from contacts. California's contacts are related to law. And think about whether or not there's a long-arm statute, if the application of the long-arm statute is constitutional, if it abides by the Fourth Amendment Due Process Clause and meets traditional notions of fair play and substantial justice. Under ISHU, if the cause of action not related to minimum contacts, the general jurisdiction over defendant needs to be shown as systematic and continuous contacts. Look at the relationship between lawsuits and contacts. If the cause of action arises out of a specific jurisdiction, and if it doesn't, then look whether or not general jurisdiction applies. And so defendant may have contacts with the forum state related or unrelated to the cause of action. Related contacts weigh more heavy in favor of jurisdiction than unrelated, but unrelated contacts of continuous and systematic substantial may support general jurisdiction between the state court, between a single contact which may support jurisdiction when a cause of action arises out of that single contact, or even in an act committed outside the state that has consequences within the state. So fairness factors for general jurisdiction always look to the relatedness of plaintiff's claims to defendant's conduct, forum state's interest in adjudicating the dispute, the convenience to the defendant, who's always going to complain about inconvenience, and whether or not there's a high standard by placing defendant, the burden of showing forum is so grossly unfair, would be seen as disadvantaging in fighting there, or a disadvantage. And how do we determine or define minimum contacts? We define minimum contacts by looking for these factors: purposeful availment of forum state, substantial connection or a single tortious act, foreseeability, and stream of commerce plus, where we look at it's not enough just to be within the stream of commerce of that state. We also want to see something more like purposeful availment and something more than just a website listing information. We want active engagement. So we're almost to the second half. Remember, look at fundamental fairness, which can serve as an independent basis for denial of personal jurisdiction. In the Sahi case, for convenience, reasonableness factors, we look to the burden on defendant, interests of foreign state in adjudicating the matter, plaintiff's interest in relief, judicial efficiency, and shared. We look to the interests of states in furthering fundamental social policies. In Burger King, if defendant has minimum contacts, the burden is on the defendant to prove defending the suit would be fundamentally unfair. Convenience for defendant only goes so far. Out of tech contacts for personal jurisdiction, the Zippo test, a passive website is not sufficient for personal jurisdiction. Active website, which does some sort of business with customers, that is sufficient. But interactive websites or exchange info might be sufficient, but it depends how you argue the facts and stream of commerce plus. So in the Goodyear case, state may not exercise general jurisdiction over a foreign subsidiary of a U.S. corporation where subsidiary lacks continuous and systematic business contacts with the state. So general personal jurisdiction arises from defendant's continuous and systematic affiliation with the state and permits state to exercise personal jurisdiction over defendant for any claim, regardless if the claim is connected to defendant's activities in a state. So specific jurisdiction, however, arises from connection between state and underlying claim, permits state to exercise jurisdiction with respect to that claim. So community trust is another case. The company purposefully avails itself of the privilege of conducting business and state of the company website if it's interactive enough to conclude that the company intended to interact with the residents of that state. So remember there, Personal jurisdiction, or I'm sorry, subject specific jurisdiction, a defendant must purposefully avail himself of the forum state. We're looking for something beyond the market, like a market plus an agent. The cause of action there must arise enough in defendant's activities in that state. And remember, the acts of defendant must have substantial connection with state to allow exercise of jurisdiction without violating due process. So in Schaefer, that still requires due process under minimum contacts, even where property is intangible. All assertions of state court jurisdiction must be evaluated by based on the state or by international shoe and its other cases. Minimum contacts and notions of fair play and substantial justice now apply to property cases. And then ask yourself if it doesn't kill quasi in rem in its entirety, but severely limits. Ask if it is to gap between states, the long arm statute, and the 14th Amendment due process clause. We still got a lot more to cover, but I think we'll do this for about 10 more minutes, and then we'll finish the second half. We still have got to cover a lot of these other concepts here. Just give me a second to review what we should do next. So we talked about the Schaefer case. We'll move on. So minimum contacts must exist in order for in rem jurisdiction to attach. Under Schaefer, principles of minimum contacts and fair play and substantial justice from international shoe also apply to all assertions of state court jurisdiction. A shareholder derivative suit over stock in Delaware against Delaware defendants, only remaining utility for quasi in rem suit in Washington has a gap, doesn't reach the limit there. In rem, not affected since specific jurisdiction usually exists under Rhodes. And the rule that we get from this case is that jurisdiction cannot be founded on property within a state unless there are sufficient contacts with that international shoe test, within the meaning of the international shoe test. Mere presence of property is insufficient to confer jurisdiction to the state court where property headed on court about independent contracts per international shoe. Here, the suit against directors, the site of any non-residence there of defendant is in forum state. In rem jurisdiction is subject to the minimum contacts analysis. So in rem jurisdiction appropriate only where defendant purposefully avails himself to benefits and protections of a forum state, or where there's sufficient relatedness between the causes of action and the forum state. Here, since there are duties to shareholders not related with stock, the lawsuit is actually unrelated to defendant's contacts in the minimum to the forum state. So minimum contact there is required for state court to exercise quasi in rem jurisdiction. So even if defendant has property within forum states cannot alter the out-of-state defendant personal jurisdiction if without minimum contacts. They can't actually apply that. So Pennoyer's requirement of attaching that property's property requirement, there's a two-part analysis for in rem and quasi in rem, where there's a statutory inquiry, must be attachment, statute, or sequestration. Constitutional inquiry, where quasi in rem is okay if it's attached at the outset of litigation, but quasi in rem must now be seen in context of international shoe. Quasi in rem may still be used in place of the long arm statute to grab the defendant, but as for a pure in rem actions, Schaefer seems to indicate that minimum contacts be required, but it wasn't really clear there. Quasi in rem is used as a means of holding property in state without when litigating out of some sort of issue on a financial issue, Property has not and still cannot serve as a basis, however, for general jurisdiction. So I think we'll stop at subject matter jurisdiction. We're almost there. We'll do these 4 pages, and then we'll leave the next video for subject matter jurisdiction and supplemental. So in Burnham, service of process of someone physically in state sufficient to establish personal jurisdiction for in personam. So there's that physical presence traditional notion. So the minimum contact standard doesn't apply. It's not a violation of due process. Physically present defendants from absent ones, Schaefer, DNA. If the international shoe standard is just a substitute for presence, however, remember that. Tradition and uninterrupted practice of recognizing the jurisdiction satisfies the due process requirements for traditional notions of fair play and substantial justice. In Brennan's concurrence, we get that conduct analysis under Schaefer, purposeful availment, and instead we also get this long-arm statute, long-standing tradition as sufficient. So when do we get this jurisdiction? Well, service of process is invalid if deceitful action was used to bring defendant into the jurisdiction of the court, like in the Tickle case. 14th Amendment of due process does not change a state jurisdiction over a person personally served with process. Temporarily in a suit unrelated to activities in the state. So we also get Carnival Cruise Lines, a forum selection clause, where we get, for example, a clause in a contract stipulating any legal disputes confer personal jurisdiction over parties in that forum. Consent, a defendant who fails to raise an objection to personal jurisdiction and answer was actually their right to raise an issue, form of objection. Special appearance appears in court to challenge jurisdiction. Defendant agrees to abide by the court's rulings on an issue and the manner the court determines. But then we see this other Ireland case. Failure to follow court's discovery, agrees to abide by court's discovery there as waiver to personal jurisdiction claim. If objection is correctly raised, then the burden is on the plaintiff to show the challenger jurisdiction. And so through collateral attack, Pennoyer, their efficiency, it may inquire info, their enforcement based on policy consideration, clear forum benefits, all parties, for example, litigation dollars for business, lower ticket money for customers, subject to judicial scrutiny for fundamental fairness. Forum selection clause must be reasonable given the nature of the parties, and it must be beneficial for the international corporations in different courts to stipulate a forum. So remember, a forum selection clause is not fundamentally unfair solely because clause was not negotiated. Mobile Party Cruise Line has special interests in limiting the number of forums where it can be served since they're cruise and they go to multiple states. Remember that this is also based on efficiency, so the courts can determine the correct forum. And passengers purchase tickets with forum selection clauses who enjoy reduced savings based on this benefit of only having to adjudicate cases in a select amount of forums. So, jurisdiction in federal courts. Remember that generally there's no nationwide service of process. There are policy reasons for this. Due process, there's no interference with another sovereignty. Federal system is entire nation. Undue burden for federal court. There to order defendant in California to fly across the nation and litigate in a state like Maine. The U.S. has rules or statutes for imposing territorial limits upon exercise of personal jurisdiction by federal courts. Federal court may only extend personal jurisdiction over defendant when the forum state would be empowered to do so. Exceptions. Permits service outside the forum state, but only within the limits of the court and only to add third party under 1419. And permits service on defendant subject to federal interpleader jurisdiction. Permits service on defendant when authorized by another federal statute. Permits service on defendant against when federal law claims that was made in cases which defendant is not subject to jurisdiction of a single state and it is constitutionally permissible. When we're challenging personal jurisdiction, remember the traditional common law approach, where we make a special appearance to specifically contest personal jurisdiction, but the defendant must be careful not to contest any other issues of pending actions. Otherwise, he might be deemed to have consented to personal jurisdiction. And making the motion to dismiss on grounds of lack of personal jurisdiction is a great solution for that. And so procedural due process, general rule there, requires that party may not be deprived of life, liberty, or property without having been given notice and an opportunity to be heard. When we talk about notice, we look at the constitutional law requirement. In order to satisfy due process, notice must be given to a party by means reasonably calculated under all the circumstances to apprise the party of the case. So the source of that is the Mullane case, where notice by publication fails to comply with due process when the addresses and the names of the parties are known. You can't just publish, you could just, send them a writing. So some notes from Mullane: notice by newspaper publication is still sufficient, however, but only as a last resort. So really looking to the context of facts if that is reasonably calculated notice. And the FRCP comports with that Mullane case. Mullane doesn't require best method be used, but only a reasonable one. And so remember, in another case, Jones versus Flowers, notice was known to have failed, but another method was not attempted. If you know you failed, you must try other means. A variety of mechanisms might be necessary. Mullane is like the international shoe of notice. Reasonableness offers defendant a higher protection there, but does not guarantee notice. And so just remember that we want a reasonable extent. So the reality of notice, it's purely instrumental. Consensual aspect of notice, if you consent to certainty of notice, then you waive your right to constitutionally mandated more reasonable methods of notice. So notice is valuable in that it is often instrumental in interested parties, and notice is only necessary if interests of parties not represented. So that reasonably calculated standard, notice must be given to party by reasonably calculated means under the circumstances to apprise interested parties of pending action and affect them opposite to present their objections. In cases where large numbers of small but identical interests, notice only needs to be reasonably calculated to reach most of those interested. There are two components there. Notice of such a nature as reasonably to convey the required info and affords a reasonable time for those intended to make their appearance. Also look for notice by publication insufficient where names and addresses of parties are known. So disputes involving property may assume that attachment of property will provide reasonable notice to interested parties, either property abandoned, not depriving anyone of use, absent party has left, caretaker to let him know about any dispute. In Mullane, caretaker is precisely person misusing the property. Flowers, where notice is known to have failed, another method must be attempted. Certified mail typically satisfies this, except in Flowers, where subsequent regular mail is sufficient. And so if we have known beneficiaries where addresses are known, then direct notice by mail in this case is required. Plaintiff must put a good faith effort to notify. Unknown beneficiaries, change addresses, beneficiary died, use your due diligence to find class members. If you can't find the publication, if you can't find them, then publication might be okay, but just look for a reasonable effort to give notice as needed. So contingent interests, future beneficiaries, they get no notice because not currently in the lawsuit. So whether proper notice was given is fact-specific analysis, as we mentioned, of whether a method was reasonably calculated under the circumstances to give actual notice. What matters is appropriateness, not whether or not defendant actually got notice. So requirement of reasonable notice, personal service of written notice when jurisdiction is always adequate. Notice must be reasonably calculated to reach defendant. Consider dignity, embarrassment, defendant's interest in litigation, deterrence, litigation as a mechanism for influencing behavior. Actual notice equals literal receipt of copy of complaint or summons. Formal notice, compliance with rules for effective service of process, notifying the defendant. Service by publication assumes people are always with their property, inefficient for an in personam proceeding. Types of process, there's hand delivery, registered certified mail, ordinary mail, service, a housemate, service on responsible agent, service by publication. Purposes, look for dignity, participation, deterrence, Look for some sort of error, and due process requirements, reasonably calculated under circumstances to give actual notice. Accounting settlements in Mullane cannot use publication alone. Jurisdiction provided by state's interest in regulating facts under its laws regarding in personam in rem, cost benefit, specific analysis, use method, most reasonable but no required, parties with known addresses, everyone gets notice, notice is necessary, unaccompanied addresses, use due diligence if it fails, notice publication, contingents with conjectural future interest, no notice necessary. Remember that they will argue each, and they'll be responding or to some notice, test by feasible alternatives, eviction notice party not as good as maybe in person, mail to the last known address, does not require heroic efforts by the government, and contests must be thorough and explain. Remember due process. Within due process is the definition of notice. That notice of lawsuit is an opportunity to be heard. Service of process is a method of delay of delivering of the complaint and the summons. Proper notice is on a case-by-case basis. Just use the best notice practicable, reasonably calculated. So next we'll talk about subject matter jurisdiction. We'll talk about diversity jurisdiction. We'll talk about different requirements for diversity. We'll talk about more areas of subject matter jurisdiction, federal question. We'll talk about, in addition, the Grabble test. We'll look to forum selection, supplemental jurisdiction, where we can get some sort of other claim to append, usually that works for diversity jurisdiction. We'll look for removal, for venue transfer, different choice of law, forum nonconvenience, Erie doctrine, and then other choice of law. We'll look at the Piper case, the Erie case, and then that will be it. We're almost there. So I hope you enjoyed this. Feel free to rewind, and please enjoy the next video on subject matter jurisdiction, diversity jurisdiction. We'll try to cover that in one video and then see how far we can get going through all of the different aspects of class actions and summary judgment and discovery and all that. That is its own beast of its own.